My name is John Flanagan. I'm the Deputy Registered Officer of the Non-custodial Parents Party Equal Parenting. We can fully sympathise with the comments made by Robert Smith in dealing with the Australian Electoral Commission, and we often find we've got the same issues. We have 57 political parties in Australia, and hardly anyone hears of any of them. Most people can only nominate 6 or 7 political parties. Our party is probably one of those 50 political parties that no one hears about. The Non-custodial Parents Party Equal Parenting was formed in 1998, and we've been around for a little while. Despite the name, it is important to note that we are not a single issue party. As a generalisation, we have slightly conservative views. However, there are some notable exceptions. Notwithstanding the previous comments, most of the party's policies revolve around child parenting, parenting rights for separated or divorced parents, and child welfare law. I will look at some of our policies. It may sound obvious, however, the Non-custodial Parents Party Equal Parenting wants to change family law. We want to minimise the government involvement and to maximise the initiatives of individual parents when it comes to parenting. We believe in equal time shared parenting, that is, unless it's not in the child's best interest to do so. There are more than 1 million children who live in single parents in Australia. The family law and child support systems does not support those children. And we want to ensure that the children maintain a continuing and close relationship with both parents, grandparents and other family members after divorce or separation. With regard to child support, there is 43% of child support payers who are unemployed in Australia. Now, just putting that to numbers, there's roughly 750,000 child support payers, of which 300,000 people do not work because of the child support system. We want that changed. And one of the causes is the actual system itself and also the legislation. What I might do is I'll just show you a section of the Child Support Assessment Act. That is Section 98H of the Child Support Assessment Act. Now, as you can see, when someone has a grievance with the Child Support Agency, they can have a review by the registrar for the Child Support Agency. But the registrar is not bound by the rules of evidence. Similarly, when there's an appeal, you appeal to the Social Security Appeals Tribunal. Before 2009, you appealed to a court. Now they've changed it to try and make the system simpler. So you go to the Social Security Appeals Tribunal, but they're not bound by legal technicalities, legal forms or rules of evidence. When you think about it, is that these tribunals have more power than a court of law. At least in a court of law, the judge is bound by the Commonwealth Evidence Act to hear all the evidence and decide based on the evidence that's provided. The Child Support Agency and the Administrative Appeals Tribunal do not have to worry about the rules of evidence. They decide on what they think, not what the facts are. This was a decision regarding Section 98H that went to the Federal Magistrates Court. The particular judge made the decision that you can see in red up there that says that Chapter 3 of the Constitution does not contain a right of due process and does not include a constitutional guarantee of procedural fairness in all cases. Now, this matter actually then ended up going to the High Court, which was subsequently dismissed. So, is that because of the legislation, these people don't have to worry about the rules of evidence. Now, we think that these sections of the Act should be removed because people have to have fairness when they come to dealing with the Child Support Agency and the Social Security Appeals Tribunal. Now, in order to overcome these problems, we require 5 legislative changes. Firstly, we want the implementation of a rebuttable presumption of equal time shared parenting. Secondly, we want to reverse the taxation treatment of child support payers. That is, so that the payee pays the tax, not the payer. Because the present time is that, say, if someone has to pay, say, $20,000 a year in child support, that is actually an extra 30% on top of that. They actually end up paying $26,000. Now, we think that's unfair, and it's also that lacks incentive for going out and getting a job. Also, we want to exclude overtime from child support calculations, and we want to set a fairer payment cap on child support payments. At present time, it's roughly $140,000 a year. We want to ensure that non-custodial parents are not financially penalised because the custodial parent chooses not to work when they have the ability to do so. And fifthly, we want to create a link between tribunal and court-ordered custody arrangements and child support payments. Because what happens now is that the non-custodial parent may have court orders. He goes along to see the custodial parent about having access to the children, and she says no, because she gets more child support. And what happens is then she goes to the child support agency and says, well, look, the children aren't having access with non-custodial parents, not because the court orders, but only because I've decided not to. They then increase the child support payments. So there's an incentive to stop having access with both parents. We also want fairer property settlements and better superannuation splitting. When it comes to court matters, we like to take it away from a court situation and have a tribunal set up. We think that will be fair with less legal involvement. Now, with regard to some of our other policies, we would like to remove the carbon tax. We would like to restrict coal seam gas mining. We would like to improve housing affordability. We'd like to improve employment rates. We'd like to have more investment in infrastructure. Thank you. We would also like to have a framework for Australians to use more Australian steel rather than imported steel. We are also against the current intervention in Aboriginal affairs in the Northern Territory. This is one of our more libertarian initiatives. We would like to remove the Army's intervention program, and we are for Indigenous welfare. We would like to see improved local manufacturing. We also believe that education should define the importance of both parents in the roles of children's education. Environment-wise, we believe that most energy will come from either nuclear or coal-fired power stations. Now, we're opposed to nuclear energy, and therefore that leaves coal-fired power stations as the only viable alternative. We think that green energy is worth supporting. However, we do not think it's a major viable alternative. We have an anti-war driven foreign policy. We're not anti-immigration. At the same time, we're not pro-immigration. We would like to have controlled levels of immigration. In other words, we support regulated immigration, because to create a viable society, we have to have more young people in this country. And at the present time, we're not reproducing enough kids, so we need children from overseas. Many of our members are in same-sex relationships. They're affected by family law and child support like anyone in a normal relationship. Therefore, we do not discriminate against same-sex relationships. We support public transport over roads. As I said at the start of the speech, our party is somewhat conservative. However, we're also somewhat libertarian. We're probably somewhere in the middle. There is more to our party than what meets the eye, and I thank you for your time.